Hello. In a previous video, we learned about construction claims, and we learned that if construction claims are not settled, they will escalate into a formal legal dispute, and that dispute need to be now resolved through different procedures or methods. So in this video, we'll learn about these methods to resolve construction disputes. So claim is a way for a contractor to protest and show harm from the owner and the architect. If this is not considered or resolved by the owner or the architect, then it will turn into a conflict that needs to be resolved. There are traditional ways to resolve disputes, and this is what we call the dispute resolution ladder. So ladder indicates that the further you go into the kind of the process of resolving this dispute over the different steps, the more implications you will have, the more effort and costly it will be for you. So there is the determination by design professional. You can negotiate, you can mediate, and you can arbitrate, and then litigate. So these are the methods here we're gonna cover in this video. So negotiation is easy. Whenever there's issue, you just call the big folks in both companies, the contractor and the owner, to sit and negotiate and try to settle that claim. Because sometimes you issue a claim, so as a project team, you work on settling things through the claim. If things are not settled in the project level, remember the organizational structures, you have operational level, project level, and business level. So if the project level personnel are not even able to settle the claim and it escalates dispute, then the business level kind of personnel will be involved. So it's the senior kind of leadership in each company will be involved, and they can involve and start to resolve it through negotiation. It's the most economical way, it's the fastest, and if there is a fair, good intentions, that the dispute will be resolved right away. The other way is the decision by the architect. So if the owner here can consult with the architect, which is funny because AIA, the architect is the owner representative. Per the AIA contract A201 for design bid build. So the owner here is kind of on the owner side in some way. So the architect here will have the power here kind of to be the judge initially. So this contract calls for the architect to intervene and try to resolve any conflicts. And that will be by just looking at the case and trying to resolve it. And this is just a visual of the different, like the article here, 4.3.3, what constitutes an event and that we have seen it in the claims part of this lesson. So what constitutes a claim, and then you can see here the durations that are listed here between each step. You have to be really careful following the procedure that's outlined in the contract. But at some point, the architect will take a decision, and this decision can be to reject the claim, which meaning that the next step, if the contractor is not happy still, they can move into the next step in the ladder of the dispute resolution. They can approve the claim. In this case here, the owner will still have to kind of accept that, but typically they will accept it, and that claim will result in a change order. They might require additional information. They might suggest a compromise, or say, folks, I can resolve that. Let's move on to the next step, which might entail going right away into arbitration or other steps like we'll see. So the next step might be mediation. So mediation is a form of settling disputes in a way that's kind of still peaceful in some way. So it requires a third party that's neutral. So they're both parties owner and contractor agree on that third party. It can be a construction professional or a company, specialized company that provides such a service. The idea here that mediators are needed for many reasons. First, both parties, the owner and the contractor, are not able to resolve the issues currently they have, but they have a desire to resolve it. They value the relationship, but still they can't figure out how to shorten the gap or close the gap. So they maybe acknowledge that we're so polarized and we need someone from outside to give us a judgment here. But in the same time, also we value private kind of proceedings. So we don't want a lot of people to know about our disputes. So that's the idea behind mediation. It's typically private. And then the goal here is to avoid more negative consequences of this claim or dispute. If mediation doesn't work, then you move into kind of a little formal way, which is arbitration. So arbitration is the last step before you go to basically court and asking for settling in court and getting attorneys involved. So initially it's private, it's informal. It's designed to kind of mimic kind of hearings and the court, but it's in a simpler way. It's governed by rules that are prescribed by law. So it's kind of in some way controlled by law and the procedures that are used for arbitration. And there are professional organizations that can provide you with professionals and guidelines on how arbitration can be conducted. So AIA, not the architects organization, it's the Association of International Arbitration, or the AAA, not the insurance company, American Arbitration Association. So these are kind of they have their own professional structure and way to certify arbitrators and train them, and you can hire arbitrators from there. And the arbitrators here hear the case from both sides, and they make a judgment. And arbitration depends on not only one arbitrator; it depends on a panel of arbitrators. And that's not that cheap. So you will need to file arbitration case with one of these organizations, AIA or AAA. So there's a filing fee, and there is also you're paying these arbitrators, and they are expensive. So there's costs related to that, and in some cases not fast because it involves hearings, and you have to kind of document the hearings. And hearings can go up to a month or sometimes years, depending on the complexity of the project and the claim. The last step of resolving a conflict is litigation, and it's binding by law. You can move further beyond that. It's just the last step, and it's the most costly step here. So I don't need to explain that. You can even watch TV shows about court cases and litigation. But the only ultimate winner in a litigation case are the attorneys. So both sides will lose money, time, but the only winner here is the attorney. So in comparing now these three main ways, I mean, we're not covering the negotiation or the architect decision, but the three main ways of resolving a conflict: mediation, arbitration, and litigation. We're covering that comparison from these perspectives here. The first one is cost. So, of course, the cheapest one is mediation. You're covering only the salary, the nice dinner that you have with the mediator. So that's it. Arbitration, you cover the filing and the fees and the salary or compensation for the arbitrator. And if you have attorneys involved, which you will have to pay that. Litigation is just a lengthy, painful process, attorney, court fees, and all of that you have to pay. Which one is more binding? Mediation, of course, is not that binding. It's take it or leave it. If you want to move forward to arbitration, you move forward to arbitration. Arbitration, the contract can say it's binding or not binding, then you move to litigation. Litigation courts have different levels, so eventually it will be binding at the end. You can appeal it at some point. You can appeal it at different levels of the court, but at some point that's it. The final decision can be made. So full appeal for the litigation. Mediation, there is no appeal. It's just arbitration if you don't agree. Arbitration, there is no review even, and there is no kind of second opinion. It's just one shot for arbitration. An arbitrator don't have to explain kind of the decision that they make. So if you don't like the arbitration, you move into litigation, but be aware that courts will consider the decision made by the arbitrator, because arbitrators are typically professionals like engineers who got the arbitration training, so they're aware of the technical issues involved here. The way or the method or the approach for resolution here, mediation is active. So you're trying to find common areas that you can resolve and you can use to resolve the conflict. Arbitration litigation is passive. You're hearing only. You're not proposing and not actively trying to resolve the issue. The meeting here are less structured for mediation, kind of structured for arbitration. You have to follow a specific process that are really required by law and also the arbitration agencies or organizations. Litigation is super structured. You have to follow very specific procedures. And then the openness of the proceedings here, the documentation for mediation, it's private. Arbitration here is private, but it can be public if you're dealing with a public project. And finally, courts. You can have access to all court proceedings and case analysis and all of that. It's publicly available, and it's publicly available to the idea here is common law or precedent law. Sorry, that when a court make a decision about a case, that decision is considered in future cases. So that's the purpose here. You need to make everything public. So bottom line, mediation, of course, is better. It's cheaper, quicker, easier. But if you're not satisfied and you feel you have more right into that claim, you will move up into this dispute resolution ladder, arbitration, litigation. But once you reach litigation, that's a big loss here. The only winner is the attorney. All right. Thanks for watching. Take care.